Good morning, friends. Let us dive into a case law that is SHILPA SHILESH versus VARUN Srinivasan. It was decided on 1st May 2023. Friends, the bench constituted was Honorable Justice Sanjay K. Kaul, Honorable Justice Sanjeev Khanna, Honorable Justice Abhay S. Oka, Honorable Justice Vikram Nath, Honorable Justice Jitendra Kumar Maheshwari. So, friends, let us dive into this case law. The questions before the bench were whether the Supreme Court can, under Article 142 of the Constitution, grant divorce based on mutual consent of the parties, bypassing the waiting period under Section 13B of the Hindu Marriage Act 1955, shortly HMA 1955, and also quash other proceedings connected there. If the answer is yes, what are the contours of this power? Second question was, can the Supreme Court grant divorce under Article 142 despite one spouse's objection in case of irretrievable breakdown of marriage? So, friends, I am again repeating the question which were put before the Honorable Bench to decide. First one is whether the Supreme Court can, under Article 142 of the Constitution, grant divorce based on the mutual consent of the parties by bypassing the waiting period under Section 13B of the Hindu Marriage Act 1955, shortly HMA 1955, and also can quash other connected proceedings. If the answer is yes, what are the contours of this power? Second question is, can the Supreme Court grant divorce under Article 142 despite one spouse's objection in case of irretrievable breakdown of marriage? So, to answer this question, let us first know the factual background. A transfer petition was filed in the Supreme Court for the transfer of divorce proceedings from one state to another. During the course of proceedings, the parties agreed to divorce by mutual consent and arrived at a settlement. The parties sought the Supreme Court intervention under Article 142 of the Indian Constitution to dissolve their marriage. Friends, Article 142, subclause 1 of the Constitution grants the Supreme Court the power to do complete justice in any cause or matter before it. The division bench of the Supreme Court, which consists of two judges, found that there was an irretrievable breakdown in the marriage. Recognizing the backlog in family courts, the Honorable Supreme Court dissolved the marriage under Article 142, bypassing the lengthy process in the family courts under the Hindu Marriage Act 1955. The Supreme Court acknowledged a surge in similar cases before the Supreme Court seeking relief under Article 142. On 29th June 2016, the bench referred the matter to the Constitutional Bench of 5 judges to clarify the scope of court's power under Article 142 of the Constitution. So these are the facts. Now let us explore the decision of the Supreme Court. The Constitutional Bench held that the Supreme Court can record the settlement between the parties and dissolve the marriage by passing a decree of divorce by mutual consent in exercise of the power under Article 142 of the Constitution without being bound by the procedural requirements under the Hindu Marriage Act 1955. The court also held that while exercising power under Article 142 of the Constitution, the court can quash and set aside other proceedings between the parties, including criminal proceedings. Furthermore, the Supreme Court held that under Article 142, subclause 1 of the Constitution, the Supreme Court could grant divorce if the marriage has irritably broken down, even if one party opposes the prayer for divorce. Finally, the court clarified that parties could not approach the Supreme Court directly to dissolve the marriage under Article 142. Rather, parties would have to approach the family court as the court of first instance. The judgment of the court was authored by Honorable Justice Sanjeev Khanna. Now, friends, let us dive into the reasons for the above decision. Firstly, the scope and ambit of power of Supreme Court under Article 142, subclause 1 of the Constitution of India. The Supreme Court held that Article 142, subclause 1 of the Constitution gives wide power to the Supreme Court to do complete justice in any cause or matter. The court held that this power, while broad, is restrained by fundamental considerations of general public policy, fundamental rights, secularism, federalism, and other basic features of the Constitution of India, and specific public policy, as for example, some express prohibition in any state. It was held that while the court cannot create new laws or disregard explicit statutory provision, it can intervene in areas where the law is unclear, as long as the court's action uphold the principles. The court may deviate from procedural and substantial law to do complete justice between the parties. Supreme Court can grant a degree of divorce under Article 142, subclause 1. Section 13B of the HMA provides for divorce by mutual consent, subject to a mandatory cooling period of minimum 3 months and maximum 18 months. The Supreme Court clarified that the cooling off period of 6 months can be waived in exceptional situations where prolonged court proceedings have already caused significant distress to the parties. The purpose of the cooling off period is not to prolong suffering or salvage irreparably broken marriages. If reconciliation efforts fail and the marriage is totally unworkable, then the court can grant divorce without waiting for the cooling off period. The Supreme Court finally held that while exercising power under Article 142, subclause 1 of the Constitution, it can grant divorce based on mutual consent without requiring parties to file joint motions before the trial court. Even if the main case is pending elsewhere, the Supreme Court's power extends to granting divorce by mutual consent, thereby easing the burden on multiple courts and parties. Based on the settlement reached between the parties, the court has the power to appropriately deal with other proceedings between them, whether civil or criminal. Court can grant divorce under Article 142(1), even if one spouse opposes such prayer. The Supreme Court held that under Article 142, it can dissolve the marriage on grounds of an irretrievable breakdown of marriage, even without the consent of both the parties. However, it observed that such a remedy could not be claimed as a right, what was a discretionary power of the court, requiring careful consideration of several factors. Factors like duration of marriage, long separation period, nature of allegations, attempts at reconciliation, the orders passed in the legal proceedings from time to time must be assessed cumulatively. These factors have to be evaluated, keeping in view the economic and social status of the parties, including their educational qualifications, whether the parties have any children, their age, whether spouse and children are dependent, custody of children, alimony, and other pending matters are also relevant. A party cannot directly approach the Supreme Court for filing the writ petition to seek divorce on the grounds of irretrievable breakdown of marriage. The Supreme Court held that if a party is aggrieved by the order of the court, they cannot directly approach the Supreme Court or High Court and seek divorce on the irretrievable breakdown of marriage through writ petition under Article 32 or Article 226 of the Constitution. Instead, they must appeal to the appropriate superior court or tribunal. The directed jurisdiction of the High Court and Supreme Court is meant for enforcing fundamental rights under Part 3 of the Constitution, not for challenging judicial orders. Therefore, leave or divorce cannot be directly sought through Article 32 of the Constitution. So this is all about this case. So please read it again and again so that you may get good marks. God bless you all.